Hi everyone, Harry here to talk about what seems a kind of modest everyday motion, an unopposed motion by the government for extension of time. But it's not everyday and it's not pedestrian. This is in the January 6th Chutkan case. And recall that after the Supreme Court sent the mandate back down, Chutkan gave the parties a couple weeks to put together a schedule, a joint statement, and at least maybe sketch out their positions. And yesterday, here's the headline, is that Jack Smith comes in with an unopposed motion saying, could we please have 3 more weeks to do this thing, to actually give you a statement of our general schedule and how we think you should proceed. And the Trump team, of course, doesn't oppose it. This is, I believe, the first time that there's been a effort on the part of the Jack Smith side to delay things, every other one has come with Trump first. All right, they asked for 3 more weeks, and they write to Judge Chutkan. The government continues to assess the new precedent set forth last month in the Supreme Court's decision in the immunity case, including through consultation with other Department of Justice components. Accordingly, the government requests the court enter an order requiring the parties to submit their joint status report by Friday, August 30th, and then have the actual hearing sometime thereafter. A lot of things to say here. So first, this is noteworthy just that they're asking for 3 weeks. They have known since the opinion issued July 1st, in other words, about 40 days from yesterday, what they've needed to do. And 40 days hasn't sufficed for the Department of Justice to not have every chapter and verse, but just to get its basic positioning together to submit to the court and then go forward to sort of work through as against what will surely be the conflicting Trump position. 40 days in the context of an important and critical case is a lot of time, I'm here to tell you. And I have seen fast drills in the DOJ that got a lot more done, a lot more quickly. And then there's something that catches my eye about 3 weeks. It's a kind of a nervous amount of time to me. It's like, well, they know for sure they can't go back again, so they want to give themselves a little room, but it's not really much time, so they must be fairly close. But if they were fairly close, why, didn't they have it together 10 days ago to be able to drive this to closure? So that's kind of intriguing and maybe a little worrisome. Second point that this makes clear to me, I've always been of the view, but in contrast to many well-known colleagues who you guys see regularly on the channels, that there is not going to be an evidentiary hearing, mini trial, as pundits have optimistically called it, in this case before November, which proponents of hope would give important evidence to the American people. Here's what Pence told Trump and the like. I've been of that view, not because it's been certain to me that the department doesn't want that hearing. It's actually a very tricky position for the department if they want it or not. And just to quickly raise one point, it's not the normal kind of thing for prosecutors to do because it shows their cards a little in advance. But it's the last gasp of getting certain damaging or relevant information before the American people. But to me, it's been certain that Trump would oppose it and that any opposition, given the ability to have interlocutory appeals, would doom the prospect. To me, the one point that comes home with a 3-week request like this to take us to the end of August and then not even have a time scheduled for the hearing, DOJ has concluded and maybe wants there to be no mini trial here, which makes it more likely that there will not be, maybe much more likely, because it's so inconsistent, this sort of 3-week period with really getting galloping, which you have to do at a minimum to have that mini trial. So I think it brings that home. It's significant, A, on the facts of whether there will be one. I think my position is all the stronger. And B, does the DOJ want one? Or are they now basically resigned to knowing that if Trump wins the election, everything blows up? But if he doesn't, they can proceed with all deliberate speed and get their, ducks in a row exactly as they want to. That's the second point that comes through to me. The third point that comes through to me is reading between the lines of Jack Smith's first statement. The government continues to assess the new precedent, including through consultation with other DOJ components. So he cites the regulations that basically say he should act here the way a U.S. attorney acts. How would a U.S. attorney act? This would now go to the Solicitor General, who would convene all the stakeholders. So what this means to me is there are other stakeholders that are being convened, and you can imagine there would be several. It's such a broad opinion by the Supreme Court. You don't know how they'll appeal it in the future. If you want to try to trim it, what do you do and what line do you take? But the Civil Rights Division, the National Security Division, the Criminal Division, probably the Civil Division, even though it's a rule for criminal law, all of those have opinions to proffer, and those have to be worked out. And whether it's a very bloody kind of process or just a time-consuming one, it is somewhat hard to say. But either way, it's clear from the papers that there is quite a bit of discussion and cross-discussion going on. Again, everybody could have known that as of July 1st when the opinion came out, and in cases of equal complication, the DOJ does its work easily, especially when the work is here, just to submit a status report within 40 days. So it's still something of a puzzler. Probably we will find out down the line exactly what happened, but it's not even certain that we will. So we now will have another 3 weeks, and then she'll set the hearing. We come to a point soon where the DOJ, there's this oft misunderstood principle of when you can take certain actions in the shadow of an election. But an indictment is one such action, at least if it's not sealed. And so I think to the extent one of the actions in the offing is a new indictment that would try to tack around the portions that the Supreme Court has clearly indicated amount to official conduct, also probably not to be seen until the election. So bottom line is we are in a situation where November, as in other cases, is just by the boards. And the department's on a sort of 1 foot in front of the other posture, and meaning if Trump wins the election, the whole thing implodes, goes away completely. On the other hand, it remains, and what's very interesting about this sort of bland motion is what it suggests about what's happening within the Department of Justice, what struggles the Supreme Court's very broad opinion have generated there. We'll know a little bit more when we see the hearing, but for now, even this bland couple paragraph motion for 3 more weeks tells us a fair bit. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.